Good afternoon, everyone. Welcome to today's webinar on all things contractor related in France. Thanks for taking the time out of your day to join us. We'll obviously wait a minute or two before we get started to let everyone join today. We've got people joining from all over the UK and Europe, which is fantastic. A little bit of housekeeping. If you've not been on one of our webinars before, then you are able to ask questions, and please do so. As we run through the session, you'll see at the top of the screen there's a Q&A button. If you have any specific questions that you want to ask Maud or Jerome or Charles, then please pop them into the Q&A as we run through the topics, and I'll make sure that we can try and leave 15 minutes or so at the end of the session to cover those off. We've still got a few people joining, so we'll wait another 30 seconds or so before we get started. Also, don't be strangers. Please do say hello. You can go into the chat and say hello and let us know where you're joining from. That'd be great. Looks like the joiner numbers are starting to settle down now, so I think we're in good shape to kick off today's session. So welcome everyone to today's webinar, where we're focusing on the compliance and legal considerations for businesses to be thinking about when you're engaging temporary or contingent workers in France. The plan is to spend about 45 minutes or so to explore how the French labour frameworks differ from the UK, and we'll look at specific topics that will help us understand what that means in practice for businesses like recruitment agencies, recruitment platforms, and end hirers. We've got 5 topics to weave through today. So the first one we'll start off with is terminology. So as we know, if you've attended any of our other webinars, it's often useful to get a bit of context as to the terminology that's used in country for describing the various ways that we can engage temporary labour. So Jerome will give us a run through of that. We'll then move on to look at, which is always a popular topic, worker misclassification and how that is handled in France. We'll then discuss the various ways that contractors can be engaged. So at a high level, that would be employed solutions, agent of record or self-employed solutions, and statement of work. And as we'll learn, this is very nuanced in France, and there are a number of different ways where you can engage workers. We'll then look at what UK businesses, particularly recruitment businesses, need to think about if they want to set up in France and employ temporary workers. And then the last topic we'll finish off, Maud will signpost to us future legislation that we need to be considering, and any regulatory changes that are on the horizon that may have an impact on the market. And then at the end of the session, once we've finished the topics, we'll then go into Q&A. So please do submit your questions in the Q&A section as we move through, and I will tend to leave about 15 minutes at the end for us to cover those off. So today's webinar is brought to you by Giant Group. We are a leading contingent workforce management company that have been operating for now over 30 years. I'm delighted today to be joined by Osborne Clarke, an international law firm specialising in employment law and contingent workforce. From the Parisian office, we have Jerome Scapoli joining us. Jerome is a partner and leads the employment team in Paris. He supports and advises French and international companies on the full range of labour issues and HR strategy. His areas of expertise include all aspects of employment law, social security law, and welfare benefits. He also handles litigation matters in front of the French courts. Jerome provides services and has significant experience in the management of complex operations and reorganisations, looking at things like HR, impact of transfer activities, restructuring, outsourcing, etc., etc. So we're super delighted to have Jerome on the call with us today to weave us through some of these topics. And he has a particular specialised interest relating to the impact of digitalisation on employee relationships. Secondly, we have Maud Passanier with us. Maud is a senior associate in the employment department. Maud provides legal advice in employment law, from conclusion to potential termination of employment relationships, That includes all the HR related questions that can be raised in the performance of those employment arrangements. She also offers assistance regarding labour relations matters such as functioning employee representative bodies, running of collective bargaining arrangements, anticipation and management of the social impact of companies' transformation and reorganisation. In addition, Maud assists clients in litigation matters also, specifically on employment and labour law. Prior to joining Osborne Clarke, she gained experience in employment and labour law, working as an in-house legal counsel in the software industry for a French-based international business. So welcome to you, Maud. Finally, we have Charles Dorr, Sales Director for Giant Global. Charles focuses on helping clients access talent globally and compliantly using Giant Global's international payroll services. So a lot of Charles's client base will be joining today, UK recruitment businesses who look to place internationally and overseas. For me, I'm Dan Haslam. I'm Chief Business Development Officer here at Giant, and I'll be the host of today's webinar. I will say in advance that French was never my hot topic at school, so apologies for any pronunciation issues being a Lancastrian and French, but I'm sure Jerome and Maud will keep us straight on the exact pronunciation of a lot of the terminology that we need to cover today. So welcome everyone. So let's get right to it then, and we'll move through into our first topic, which is looking at French terminology for temporary labour. Good afternoon, Jerome.
Good afternoon, Dan. Thank you. Thank you for your introduction.
No problem. So it'd be great if you can kick this off then. And I think as we've seen, France has got very specific legal terminology when it comes to engaging workers. And why is it that that terminology is particularly important in France as opposed to other European countries?
Oh, it's a long story, but I'm not sure the terminology is more important in France than, for example, in Germany, Belgium, or Italy. I think the main topic is that the French law is not a common law, but a written law. And then it's true that employment relationships in France are governed by an extensive body of written rules codified in the French Labour Code. And so it's true that terminology is very important. And with a normative framework, we know that each term has a specific legal regime. And so, of course, using an imprecise term could lead to incorrect legal classification and then perhaps litigation. But what you must have in mind is that using the good terminology could be a protection for the employer and for the employee. And because then we will know exactly what will be the rules.
Yeah, that makes sense. And I think we're all, if you're familiar with the contingent temporary labour market, we all throw around different terminology to describe different things. So I think trying to be clear on exactly the right wording is obviously going to help, especially when you're trying to explain a matter legally. So it'd be really useful actually if you could walk us through some of those key terms that UK businesses need to understand, such as interim, CDD, CDI, portage salarial, etc. It'd be great if you can give us a run through.
Yes, of course. What we must have in mind is that the French laws provide for several types of employment contract or type of employment. The two most common are the permanent, unlimited term contract, contrat à durée indéterminée, CDI, and the fixed term contract, which is the contrat à durée déterminée, CDD. The CDI is the normal and default form of employment contract. It is a permanent open-ended contract concluded without limitation of duration. The fixed term contract, CDD, is regulated by the law and only permitted in specific situations. But we have alternative form indirect hire. It could be interim, which refer to temporary agency work, where a worker is employed by a temporary work agency to be assigned to a user company for a limited period of time. It is a tripartite relationship with two contracts. between the assignment contract worker and ETT, and the supply contract between the ETT and the user company. In parallel, we have the portage salarial, which is also a tripartite relationships, where freelancers to carry out their activity as employees. The portage company is not required to provide work to the employee, who find their own clients. And you refer to prestation service, provision of services, we could say, which is a commercial contract where somebody brings and delivers services under their own responsibility using their own resource. This is normally not an employment contract.
Yep, no, that makes sense. That sounds certainly like a non-employee type arrangement. So thinking about these French labour terms, which of these are sorts of mostly commonly misunderstood by UK businesses when they enter the French market? Are there any particular areas where you see businesses not quite understanding the terminology?
We could refer to, based on our experience, to the most commonly misunderstood terms, to the following three. First, the mutual agreed termination. Mutual agreed termination in France, is not a private contract, the same as a private contract in the UK. The mutual agreed termination is a way to terminate a contract, but subject to mandatory procedural rules with one-on-one meetings, observation of a cooling period, validation by the labor authorities. At the end, in total, it will take about 1 month, 1.5 months to terminate a contract. With this kind of termination, which is protective for the company, the employee must benefit from a minimum termination indemnity, which is in practice at least equal to the statutory dismissal compensation. Second term is the temporary work agency. I mentioned it, which is the ETT, and it is not exactly the equivalent of UK terms. But their activity are subject to significant regulation. They have the business of hiring people to put these people in using company. And the last term that I could refer to is the CBA, collective bargaining agreement, which is not a non-binding industry handbook. It is a binding collective bargaining agreement concluded in a sector of or branch, which set minimum wage, define employee classification, regulate working time. It is very important to refer to what is the applicable CBA to the business in order to know exactly, in addition to the labor code, what would be the applicable rules.
Okay, well, there must be lots of those arrangements then, I suppose, Jerome, to try and cover the variety of various sectors that people operate in. So it's definitely, I mean, it's useful to know that if you're operating in certain sectors, you've got to establish which CBA is going to be applicable there. Are there any particular engagement models that sound similar to UK concepts but operate slightly differently in France in your experience?
Sometimes we make a parallel between unlimited term contract, CDI, and permanent contract in the UK. But we have some notable difference regarding the termination process, the dismissal process, because we need to dismiss somebody, we need to have a soil and a real ground to be verifiable, and the employer must follow a specific process to terminate the contract. What we have, we have also some difference between the unlimited term contract, the CDD, and the UK fixed term contract. In France, as the CDD is an exception compared to the CDI, its use is limited to specific cases listed in the French labor code, such as replacement, temporary activity increase, seasonal position, for example. And what we must have in mind is that it cannot permanently fill a position related to the normal activity of the company.
Mhm.
At the end, something which is now well known is the annual arrangement in days. The annual arrangement in days, salarié en forfait jour, is a scheme to which allow the working time to be calculated in days on a year rather than in hours, and then no overtime to be paid to the employee. It is very comfortable, largely used by the companies, but we must have in mind that it must be authorized by the CBA, and it requires an individual agreement with the employee. And if we choose the forfait jour, the annual arrangement in days, then the employer has the obligation to monitor workload and work-life balance of the employee.
Jerome, just as and it's not a planned question, but I was just thinking there, what are there any particular sectors that would drop into that forfait jour scheme arrangement that you see? Any particular types of workers?
It is more for white collar people, executive position, and most of this kind of activity and the IT activity. For workers and blue collars, it is less common to use a forfait jour.
Okay, that makes sense. And 0 hours contracts, that's something we have in UK. Is there an equivalent in France?
There is no specific equivalent and direct equivalent in France at 0 hour contract, but we have some contract providing flexibility, such as temporary agency work, portage salarial, that could be helpful for companies.
Yeah, brilliant. Thank you very much, Maud. It's great to have you with us. And now over to you to get stuck into that always thorny issue of worker misclassification and trying to understand whether or not someone should be treated an employee or treated as genuinely self-employed. So I'm fascinated to hear what is the French system, the French approach to try and understand whether someone is genuinely self-employed versus an employee.
Yeah, well, thank you, Dan. What we have in France is that everything revolves around the definition and the notion of subordination. When you have a relationship that implies subordination, with the person performing the work being under the subordination of the one ordering the work, then we have an employee. If we do not have this subordination, we have a self-employed person. Strictly speaking, an employee must perform their work under the authority of what we will call the employer, because the employer will have the power to give orders, instructions, also supervise and control the performance of the work, but impose and set sanctions in case the work is not performed as expected. And these three indicators are really key to assess whether or not a person is in a situation of subordination. And if they are, then there is high risk that this relationship be regarded as an employment contract, an employment relationship, even though the contract between the two persons at stake do not mention any employment relationship or explicitly exclude an employment relationship. On the other hand, what we have is self-employed worker, and a self-employed worker is, I suppose, someone who works independently. They are not subordinated. They usually provide the services with their own resources, and the own resources of the self-employed worker is really a key element, but they also set their own fees, their own rates, their own working hours, basically their own working conditions, and they are not bound thus by an employment contract. So there are some clues in either situation that may indicate whether or not a worker is self-employed or an employee under a subordinated relationship. We have a presumption that is rebuttable for some self-employed workers, but since it is rebuttable, we cannot exclude litigation, especially when the contract terminates, a litigation where the self-employed worker or the allegedly self-employed worker challenges their situation and say that they are under a subordinated relationship, meaning that they are employees and eligible to all the protection attached.
Yeah, okay. Well, that's definitely a concept we're familiar with in the UK, and we hear this in many countries. You're obviously very closely looking at the level of supervision, direction, and control of how that person is operating in the role, and that's obviously a key indicator of status, and that's something we're familiar with in the UK. Are there any other areas that you would highlight to the audience in terms of how the French approach differs to IR35, as we call it, in the UK?
Yeah, so we do not have the same in France, IR35, because the French approach is really different on this. What we do in France is that we focus on this subordination link to determine whether or not a worker is under an employment relationship and is therefore eligible to the whole labor law protection. So it is not something that distinguishes the social and taxes aspects as the working condition aspect. And in France, the test that we do to assess whether someone is under an employment relationship, if they perform their work under this direction of another person in return for a remuneration with all the clues that we have mentioned, then there's an employment contract, and automatically the whole relationship should be regarded as an employment relationship, an employment contract, and entitling the individual to all the benefits and all the protection attached to this, but also triggering a reassessment of all the social security contributions and the taxes that must be paid.
Yep.
In terms of responsibility, there's also an impact on this, because employees in France are protected behind their employer for all the acts that they perform as part of their duties. And with this protection, that also means that any accident that may happen in the performance of the work, it can be regarded as a work-related accident with a specific protection and an enhanced protection for the individual. Finally, what we will also see is that when we have a reconsideration of the relationship in France, the subject to statute of limitations, but the individual can claim they have been an employee from day one, meaning that they can be eligible to all benefits and protections from this moment on.
Yeah, so I think it's great to point that out. Obviously, it's an expensive issue if you've misclassified somebody and you've been failing to pay them correctly, but also give them all the rights and protections. It can be a costly business if you get that initial misclassification piece wrong. And I think that's important for people to understand the potential risks there. Just a reminder to the audience, if you do have any questions as we're running through today, then please do drop them into the Q&A, and I'll make sure that we leave time at the end to put them over to the guys. So Maud, if I can stay with you then, who typically initiates a misclassification claim in France? How does that sort of process usually start?
Yeah. Well, most commonly, claims and litigation are brought by the worker themselves. And in most cases, litigation happens when the contract, the relationship is terminated. This is when the issues raised. Obviously, when the relationship is terminated, the worker realizes that they may have been an employee, and they will claim that the relationship is an employment contract so that they can be eligible to all, like I said, the protection and the benefits. This includes the payment of termination indemnities, which happen in most cases in France. And so what happens is that they will bring their claim to the court. They will bring all the evidence that they think show and demonstrate that they were in an employment relationship. And what they will be trying to get in return, further to this misclassification, is that they will ask for payment of salaries, bonuses, overtime, also damages when they have been working more than they should have been, when they think that they were not protected against harassment or discrimination as an employee should have been, and sometimes also challenges the termination, because termination in France in most cases requires a real and serious cause. Otherwise, it's unfair. So they might say that the relationship has been terminated abruptly without any real cause, and they will ask for damages and compensation of this, what they call unfair termination. Last topic that is a common one with misclassification claims is the one about illegal work. because, as we said, if the relationship is not an employer-employee relationship, all the same protection applies. In this case, in case of misclassification, there could be illegal work regarded the relationship, and this illegal work may trigger payment of additional indemnities to the benefit of the worker. So we have various topics, and the misclassification claim itself can open door to various claims, various amounts, and various indemnities claimed by the worker.
Yeah,
Other possibility
Yeah.
on this is the claim brought up by the Social Security Administration or the Labor Inspection in case of control, where they think that a relationship should be classified as an employment relationship.
As I said, it's an expensive business with lots of potential spin-off consequences if you get the misclassification wrong, for sure. What are the most common red flags then, if we try and move this into practical terms? What are the most common red flags that trigger labour inspections or trigger an investigation from the authorities?
Yeah. One of the most common red flag is the payment of Social Security contributions. As we said, when it's not an employment relationship, there is no Social Security contributions to pay from the person ordering the job. And the French Social Security Control Body, which we call URSSAF, they will look at all the relationships that the company or the ordering company has to check whether or not the work that they have been ordering has been classified correctly. And if not, then there may be potentially some Social Security contributions not paid adequately. So this is what they will be looking for. How they can flag issues with this? For instance, if you have late payment or non-payment of Social Security contributions, but a lot of work in parallel, but also if you have inconsistencies with some turnover, some headcount, if they think that there is a lot of contractors working and probably working on permanent roles of the company, of the business, and also long-term service contracts, add additional clues and indicators that there may be some anomalies in the situation of the company. So this is why the URSSAF may decide to investigate the situation. We also have investigations from the Labor Inspection in France. Labor Inspection, they have general powers in terms of compliance with labor law in France, but sometimes they will focus on specific sectors, such as the construction industry. But they will also check if they have alerts from unions, and they will decide to do an investigation in a specific company or in a specific sector.
Okay, so just moving to the end of this topic then. So, what steps would you advise companies to take before they onboard contractors in France to try and reduce the risk of these issues arising?
Yeah, two main steps here, and they all revolve around vigilance. You must be vigilant when you hire a subcontractor, a contractor in France. First one is a statutory vigilance obligation that you have for any contract that reaches or exceeds 5,000 euro of value, excluding VAT. In this case, you must ask for some paperwork from the contractor to ensure that the contractor is compliant with all their Social Security contributions and obligations and declarations. And every 6 months, you must make sure that they remain compliant with their obligations. So that's a statutory vigilance obligation. If you are not vigilant with this, then there may be a joint liability in case of an issue, especially with the Social Security authorities, an issue of payment of contributions, and both contractors may be held liable. So this is a
low. It's quite a low value, isn't it? So that's
Yes.
probably quite a catch-all. It probably just captures every type of.
A lot of contracts,
right?
Yeah, do fall under the scope of this obligation. Yeah, this is totally correct. The other vigilance that we have is a practical one on a day-to-day basis to avoid misclassification claims. As we said, there are a lot of clues that may trigger misclassification and reclassification. So if we have a contractor not working under an employment contract, we must be sure that the terminology we use with them, the way we work with them, is appropriate to a non-employee relationship. So for instance, we mentioned the resources, so the self-employed worker must use their own resources, their own material, their own equipment. They should not be assimilated to employees. So if they need an email address, for instance, for IT purposes, their email address should visibly highlight that they are not an employee, but that they are a contractor. They should not use an electronic signature that shows confusion with the company asking them for some work. So we must be really careful in the way they work, the way they show their work, and also the way they organize their work. We mentioned no working hours. They can decide, especially when they want to be on holiday, if they want to take a day off, they do not need validation from the company ordering the work, aside from just like the business and the project needs.
Okay. Maud, thank you. It's a hard topic to go through, and you've got a lot of content there, and it's interesting to get a better understanding. Thanks for that. Jerome, we're back across to you now for the next section, where we're looking at the different types of contractor engagement solutions or models that are available in France. So on a lot of the webinars that we do, we talk about employer of record, agent of record, or statement of work as sort of three categories of how you can engage contractors. Are those engagement models available in France?
With some specificities. First, EOR, employer of record, is not as such provided by the French law. We have seen that to be able to employ somebody with another company, the more useful schemes are the intérim, temporary work, and the portage salarial. So EOR, where we have a tripartite engagement, which allows the company to legally employ worker on behalf of another company, handle payroll, HR, compliance, etc., etc. This system does not exist in France. What we must have in mind is that foreign companies, doesn't have to have a legal entity established in France to hire somebody. But when a foreign company may recruit an employee without having a presence in France, it must be registered to the French social security authorities as a foreign employer. And so this company cannot ask another one to make this for itself. Similarly, AWARE is not specifically provided by the French law, but we can consider that it's possible to use this kind of services. AWARE, we know, act as an agent of record, which refer to entity, which act as official representative of the record holder without being the legal employee of the holder. So here, the agent of record handles administrative and compliance tasks, and we can consider it's possible. It's possible in France, but the employer will stay the foreign company. And for SOW, S-O-W, it is more a framing of work as a project-based services contract. And so it is, we can make a parallel with the contract of services, the provision of services in France. And in such a case, it is more, the company will hire more an independent contractors with his own obligation, and it will be through a commercial contract service provider that the company could use, not hire, but use the worker. Yes.
Yeah. So that's fine. So they're not legally recognised concepts, but they are concepts we can use to frame the ways of engaging or getting the work done, which is really at the essence of what we're talking about here. Specifically, which engagement models then are made available to companies in France when they're looking at engaging workers under those sort of three concepts?
In such a case, we know, as I have said, the model and the principle is the limited term contract. So normally we have an employment contract between the company and the worker. All other firms are treated as exception and are regulated. And so we have several mechanisms, as I have said, such as portage salarial. So we have a tripartite relationship with an employment contract between the worker and the portage company, and a commercial contract between the portage company and the user company. In such a scheme, the consultant, yes, more than the worker, is responsible for finding assignment, negotiating fees directly with the using company. And in counterpart, this portage scheme is regulated by the French law. Normally, it is limited to 36 months per assignment and limited to occasional tasks or specific business to bring to the using company. The other example I have already given is the temporary work agency. It is the most secure system for the using company because in such a case we have also a tripartite relationship between the worker, the agency, and the using company. And if the temporary work agreement is well used, then there will be no risk of reclassification between the worker and the using company.
Okay, now that's useful. And I think under those temporary agency work arrangements, there are some licensing requirements which we'll move on to look at shortly. So I think in the interest of time, just conscious that we've still got a couple more topics to move through. Let's move forward then to our next section, which is specifically looking at that piece around licensing. And if businesses are looking to set up in France, whether that's a UK recruitment agency or an employer outside the UK, it'd be great to understand what the requirements are there. So Maud, if I can come back to you just to kick us off on this, then what are the first regulatory decisions that a UK recruitment business would need to make when they are entering France for business? Yes,
thank you, Dan. The first thing that I would recommend UK agency to look at is be aware of the French local specificities. As we mentioned, the various engagement models may differ from the ones in the UK. And also there is a key fact. French law prohibits the lending of labor for exclusively profit-making purposes. This is a criminal offense in France, except in one case. This is the case of licensed temporary work agencies. If we are not in this situation, then there is this criminal offense risk. So when we, as an UK agency, for instance, decide to come in France and operate in France, we must know which framework we want to exist within to make sure that the way we operate is legally compliant. If we are lending labor as an employer, then maybe this temporary work agency subject to this specific requirements could be a good option, but also the portage salarial company, which has stricter conditions, especially regarding the employees that can be hired through the portage salarial company, and also the fact that we said that the the worker must negotiate their own contracts with the client. It's also an option. Finally, last option possible is the one for the service provider company. So it is possible for a UK agency to decide to be a service provider in France. But in this case, they must deliver expertise and added value, not just being lending individuals, not being lending workforce only, but provide added value as services, technical skills, knowledge. This is really key to ensure we mitigate the risk of the criminal offense of profit making exclusively in the case of lending of labor. So the operating model is really critical and crucial here. How does the UK agency want to have individuals working in France, and especially whether or not there would be remote work implied, because if working remotely for French clients may not have the same consequences as working from France for clients in France, especially in employment law, but also in tax and immigration, the implications could be different.
Yeah, and we hear loud and clear, you mentioned criminal risk there. So clearly the license requirement is something that needs deep investigation from any business to make sure it's done properly. Could you just quickly give us a bit of an insight as to what that process would involve if someone wanted to apply for that license?
Yeah. So when we say license, it is more about making sure that we comply with various requirements. One of them is the fact that we must notify the administration and declare to the administration the activity, the business. So it is a registered business, and the labor inspection in particular will acknowledge the receipt of this activity. And the other main condition to have this licensing as a French temporary work agency is the financial guarantee. So any activity, any business wanting to work and operate as a temporary work agency in France, they must have a financial guarantee which ensures that in case the temporary work agency bankrupts, they can still pay the salaries and all the benefits, including the end of assignment compensation, the pay leaves, and all the mandatory contributions, that everything that is mandatory can be paid. This guarantee, it is in most cases a surety commitment from a specific company, sometimes a bank, and it can also be an insurance company. Well, anyway, this financial guarantee is set at a certain level defined by law, to make sure that in case the temporary work agency bankrupts, then the employees at least will be paid what they are owed.
Yeah, that makes sense. Charles, you've been patiently sat there. It'd be great just to bring you in at this stage, because obviously you get involved on a weekly basis dealing with contractors setting up in France as well as other countries. So it'd be just useful if you could quickly just illustrate how different are the employment cost structures in France compared to the UK in your experience?
Yeah, for sure. So, I mean, the short answer is that France is materially more expensive than the UK from an employer cost perspective, and the difference is mainly driven by social security charges as opposed to base salaries. So in France, employers' social security contributions are high and they're quite complex. Typically, you're looking at kind of 40 to 45% on top of a gross salary. And that covers off things like health insurance, pension, unemployment, family allowances, workplace accident insurance. Whereas obviously here in the UK, we've got our employer costs of the employer's national insurance, 15%. Within an umbrella structure, you normally have the apprenticeship levy at about 0.5%, and then maybe pension auto enrolment as well, another 3%. So, looking in the UK, maybe about an 18.5% add-on cost for employment, whereas France, you're looking at 40 to 45%, so more than double.
Yeah, and if we stay with you, Charles, then obviously we were talking to Maud before about things for businesses in the UK to consider if they're going to enter the French market. What's your view around whether or not partnering with an employer of record is sensible? Obviously, bearing in mind what Jerome's pointed out in terms of the different types of engagement. What's your view there in terms of a sensible entry strategy?
Yeah, sure. I mean, I think all the things that we've been talking about today, again, short answer is yes. Partnering with an EOR is often a very sensible strategy, certainly for entering the French market. As we kind of talked about, French is one of the EU countries where an EOR could actually add real strategic value. And I know we've kind of talked about the terminologies and what we call EOR, employer of record, might actually have a slightly different flavour in France, but I'm kind of using it as a bit of a catch-all for this webinar. So as we've talked about, there are high employment complexities from day one. There are high employment costs of social security. There are strict labour laws, mandatory benefits, a formal dismissal procedure. And so essentially an EOR kind of absorbs all that complexity immediately without you needing to kind of build in-house expertise. So essentially expensive mistakes are hard to unwind, as we've talked about. Fixing a bad hire can be costly. Termination risk is real. Employment litigation is common. The work council obligation can rise faster than expected. So there's lots and lots of factors that I would certainly suggest using an EOR means that you can really test the market before committing long term and taking on kind of structural risk. But in addition, an EOR really gets you speed of hire without that entity setup. So you're hiring within weeks or days even, as opposed to months. You're avoiding having to set up a French entity. You can kind of skip all the local payroll, tax, social security registrations, and you can still offer fully compliant French contracts pretty much immediately. So for companies using an EOR, I would say it's absolutely lower risk. It's faster, it's more flexible way to kind of try and test the French market, particularly given some of these topics we've been talking about today about the high cost, the high level of legal complexity.
Yeah, and we always talk about risk and cost on these calls, but it's also worth pointing out it's a big marketplace in France, and many organisations want to engage there. So it's definitely the messaging that France is open to business. You just need to make sure you've got your solutions in place and you've done your due diligence. I'm super conscious of time because we've got questions coming in. I do want to leave 10 minutes. Maud, if I can come back to you and if we can just quickly wrap up on our last topic, where we just wanted to do a little bit of horizon scanning and think a bit about what's there in the future in France from a regulatory change perspective. Any particular areas you'd highlight before we move on to questions to the audience?
Yes. So what we have in the future and what we should expect here is one of them is the EU Pay Transparency Directive. So we are not the only one. All EU is concerned about this. But from June this year, this new legislation will come into force and it will change some things in France. We do not know exactly the details because we are still expecting for the transposition bill. But what we already know is that all companies with at least 50 employees will have stronger obligations to comply with transparency about salaries. And what does it mean? It means that from the moment you hire employees in France, you will be required to indicate, for instance, in job offers, a lot of details such as salary ranges, but also you will be prohibited explicitly to ask some questions to the candidate, for instance, about the remuneration they used to receive, which up to date was still a possible question you could ask to a candidate applying for a job. Also, and the main changes are here, this directive will be changing a lot of things during the employment relationship, because employers will be required to disclose a lot of data, especially the criteria they have used to set and determine the salary that they are paying their employees, the remuneration levels, the progression, the evolution within the company. Each employee will be entitled, upon their request, to get information of the average levels of remuneration, a breakdown by gender, and also for the same work. So probably not the same job title, but the same work value. They will be eligible to receive it. They will be entitled to receive data to compare their situation. We also have another EU directive which will come into force, which is the one about corporate sustainability due diligence. It will increase the vigilance obligations, which we have mentioned. And that's, for the moment, the main two changes that we are expecting in France. We have had some recent changes with the latest budget laws. And one of these main changes is the increase in the social contribution when we have companies entering into mutual termination agreements, which makes this option to terminate employees a little less interesting in terms of cost, but other options remain, of course.
Brilliant, Maud. Thank you for the quick summary. There's always more to talk about. There's always more coming down the track for us, isn't there? I'm afraid. But great for you to point out what guys need to be considering for now. So that brings us to an end of the topics for today. So thank you to the speakers. We can now get stuck into questions. So if you've not submitted a question, please do so, and we'll try and cover them off in the next 10 minutes or so. So first question from let's have a look here. Helen. Afternoon, Helen. Hope you're well. Helen has asked, how common are claims from individuals claiming employment following termination, and how often do they succeed? Jérôme, maybe that's a good one for you to take and give us your view. So the question again is, how common is it for claims from individuals claiming employment following termination, and how often do they succeed?
Frankly, it's not so common to that an individual who have been hired as an independent through a provision of services, for example, provision of services contract. It's rare that when people ask for an employment contract. It is more when somebody is working for a company for a very long time. For example, I had some cases in the past, for example, where somebody who were working for more than 20 years in the same company, doing the same business for 20 years, using the tools of the company, working for the client of the company. In such a case, it was obvious that it was an employment contract. But in the other situation, it is true that it is more rare to have this kind of cases, litigation. And there is a question about how often do they succeed. It's very, yes, sorry, but it's difficult to answer this question because it depends the way the working relationship was made and was followed. In the example I have given, of course, it was obvious. It was obvious that it was an employment relationship. If we follow the recommendation given by Maud, for example, not to have external with the email address, to let people working with their own tool, with their own schedules and organization, it's true that we will have some very serious arguments to the court in order to demonstrate that it is not an employment contract.
Yeah, no, it's interesting. I think sometimes we can get lost here when we're talking about misclassification and forget that, you know, some workers do want to engage on a temporary basis. That is how they want to operate. And if businesses are clear on the terms in front of the worker when they agree, then it should really reduce down any confusion when you get to the end of an agreement. As we know, the rise of gig platforms and temporary work is popular, and across the EU it's growing massively. So I think it's just important to make sure that both parties are clear on the arrangement when they're entering into it, and then it should become sort of less of an issue when you get to the point of termination at the end. Maud, if I can come to you, we've had a question in from Rebecca, and I think this was around when we were talking about the use of portage companies. Rebecca's asked, just to clarify, if you wanted to use a portage company, do you still need to register as a temporary work agency in France and provide that financial guarantee, or is that covered by the portage company?
I would say that would be covered by the portage company, because if the end user, the end company is going through the assistance of a portage salarial company, and that means this end user company is the client and they do not need to provide any financial guarantee. The portage salarial company, which would be the employer of the individual, this portage salarial company will provide the financial guarantee. They will also provide the employment contract and all conditions that come with it.
Yeah, Great, that makes sense. Definitely an easy point of entry. And I know, Charles, you've used portage companies for a while as part of the global offering at Giant. Question specifically for you, Charles, from Adrian. Good afternoon, Adrian. Charles, partnering with an EOR, my understanding is that the employer of record, EOR, must employ the temporary worker and the client pays the EOR, who in turn pays the temporary worker. As a UK agency, the UK agency cannot be a party to this relationship, as this would be viewed under French law as illicit lending. Additionally, the EOR cannot source work for the temporary worker. The temporary worker can only engage with the employer of record once they have sourced their own work. This goes back to my question above, in that this model of engagement, i.e. a UK agency, can only charge a single one-off fee to be compliant with French law. Is this correct? That's a wordy one, Charles, but hopefully you got the general gist of the conversation, just looking at the contractual chain and the billing arrangement. Adrian suggesting that a UK agency can only charge a single one-off fee to be compliant with French law rather than ongoing. Have you got a view on that?
No, I mean, in fairness, the way that I have operated historically with working with French portage companies is through a normal kind of what we all call over here like an umbrella contract chain, where you have end client to recruitment agency to umbrella or portage in this scenario, and then through to the worker. Now, I know obviously in other countries like Germany, where you have the AUG legislation, there's specific legislation that is reducing the number of parties within the contract chain, and I'm sure Maud and Jerome would be better placed than myself to confirm any French requirements. But we've always operated under a kind of a standard umbrella chain where we will have contracted with a UK recruitment agency who then have invoiced their end client. Those structures have normally been where the agency is based in the UK as opposed to being based in France. So that might potentially make a difference. Again, perhaps Maud and Jerome could chime in on that point.
Yeah, it'd be interesting, Maud and Jerome, if you've got a view here. So Adrian's challenging to say, from a UK agency perspective, only permanent placements or temporary placements with a single one-off fee is compliant with French law. You alluded to it, Jerome, I think, or maybe it was you, Maud, about making profit from people that are doing work. The UK agency would only need to have a French legal entity with the necessary licenses to fill the vacancies in France. Is this correct? I think what you're saying is actually if you used a portage company that is licensed in France to look after these workers, then actually that is perfectly correct. But for you to confirm.
Yes, your understanding is totally correct. Yes, and it is the more secure system for foreign company to be able to hire somebody, but to use somebody to avoid any reclassification. That's true.
Excellent. So there you go, Adrian. You can get your French referrals across to Charles, and he'll gladly use his portage partner to service those requirements. We've got one last question. This was from Nick. Nick asked, is there anything similar to a time and materials contract which is compliant with French law that freelancers could operate on? Depends, I suppose, on what you mean by time and materials contract there, Nick, but I don't know, Maud or Jerome, if you have any views there or if you need further detail to be able to answer that question.
What exactly would the time and materials contract be? I'm not certain about this. But what I see, if we're talking about freelancers in France, is that in France, workers, and especially if they are freelancers, so self-employed workers, they can work under a standard commercial contract with the company ordering the work, as long as all the clues and all the conditions that we have mentioned for self-employed work are met. Meaning that they should be independent, they should set their own fees, they should work with their own tools. And this is why we often have issues with platforms in France, because some platforms have set their own conditions, and these conditions have triggered issues regarding the independence of the worker.
Very good. Well, that brings us up to the hour. Thank you so much, Maud and Jerome and Charles, for joining us today and going through the session. It was really, really interesting. Thank you to the audience for taking the time out of the day to listen to what we had to say as well. We will follow up with a recording of today's session, and hopefully we'll look to plan to run more webinars with Maud and Jerome in the future to keep the conversation going. Thank you to everyone. We all hope you have a great afternoon and enjoy the rest of your day.